Court does call the case of the people versus.
National Health for the People in both matters.
Assistant Public Defender Ben Dunaway on behalf of Mr. Barnhart, who stands to my right. Would you state your name for the record, please?
Philip Barnhart.
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
Report and receipt of the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
All right. This one's not easy to sit through. We're back in court with Philip Barnhart, a man whose battle with addiction keeps crossing paths with the justice system. What you're about to watch isn't just another routine bond hearing. It's a moment where a judge's patience is running thin and a defendant's chance...
And I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check ex-jail and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. So it's possible that certainly the THC could have been from before. The cocaine I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument. But
can I have just a second, Your Honor?
Sure.
To start, the atmosphere feels heavy. The prosecutor isn't just listing off lab results. He's laying out the story of someone spiraling out of control: cocaine, THC, benzos, Suboxone, all showing up after a recent release. The defense tries to nitpick the timing, but the judge's face says it all. He's heard these excuses before. You can sense it, that silent frustration, that this is not Barnhart's first time in...
It's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones. And he's still using. I don't know that he should be out because at some point, luck's gonna run out. He's gonna get behind the wheel and he's gonna take somebody out. I don't have a vehicle.
Your Honor, I don't believe he's driving.
The judge says, your luck's about to run out. That's not for dramatic effect. That's experience talking. Every judge who's seen repeat DUI cases knows how the story ends. Family shattered, lives lost, all because someone thought they could handle just one more drink. The silence that follows that warning, it hits different.
Absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point have undeniable jurisdiction to revoke his bond. I would say that I don't...
To be fair, the defense has a point. Addiction is a disease, not just a crime. Barnhart wasn't caught driving. He failed tests at home. There's that legal gray zone that raises a tough question. Should relapse automatically send someone back to jail? Or is that exactly what rehab is supposed to address?
This point proves he's actually a danger to the community.
So you're arguing to me that with all, this is legitimately 4 and 5, with another one pending in Wayne County, and he's still using, You're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I wouldn't absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. We don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve.
Can I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly, and I'm going to double check that before I make that assertion to the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is. People would request that the court find that the bond was an abuse of discretion and set a higher bond and remand.
I just don't think the circumstances have changed since the bond was set, because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. It's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
It would not be abuse of discretion because of the length of time that has passed. So, we're already into August.
Comes the prosecutor's hammer, a blood alcohol content hitting 0.3 multiple times. That's not casual drinking, that's blackout level territory. You can see in the judge's eyes, the patience finally breaks at this point. It's not just about enforcing the law. It's about keeping the public safe.
I think he was on 1 time a week. The court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set?
I'm sorry?
What did you wish these set for preliminary examination?
No, he's going to waive.
He's waiving? All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash as surety. Sir, you're waiving your right to preliminary examination in these cases?
Sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you will not have that hearing on either one of these matters, and that this will proceed to circuit court for further resolution.
Sir.
Proposal for daily testing actually sounds fair, but the trust has already gone down. Barnhart's been given opportunities. Rehab, bond, freedom, and every time he shows up dirty. Now the courtroom isn't just debating punishment. It's questioning whether change is even possible.
Examination having been waived, defendant's bound over to circuit court on the single count in each case.
Stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pretrial. Pretrial date.
September 24th at 1:30 with Judge Shine.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. The bond, as indicated, is set in each case. It will be changed from a personal recognizance to a $25,000 cash as surety.
That it's over. Bond raised at $25,000. Barnhart quietly mutters, "Yes, sir." No shouting, no breakdowns, just quiet acceptance. This isn't some villain story. It's a man stuck in a painful cycle. The real tragedy? Even when the system wants to help, sometimes it has no choice but to protect others first.